morning, Your Honor. Brandon Bird on behalf of Carlos Mack. Mr. Mack, can you please state your full name for the record?
Carlos Mack.
And this is the public defender Lord on behalf of Mr. Mack as well. I have the case ending in 1404.
Got it. All right.
Your Honor, respectfully, we'd like to adjourn this matter. I just got on the case on Friday, I believe. It's been a short time, but just been able, my client to gather discovery, etc.
And Ms. Perrine, are you in agreement with that adjournment?
Yes, I am asking for deferment as well. He would like to go to Secretary of State to see what needs to get rid of his license back.
Well, it's like one thing you may have to do is stop drinking. Have you seen the bond violation report, either of you?
I'm showing it to Mr. Bird right now. We did discuss the case earlier, and I didn't realize that Mr. Mack had a bond violation. So
Got it.
Mr. Bird's just seeing it right now for the first time. I apologize, Your Honor.
And honestly, Your Honor, to be truthful with the court, Ms. Wiley sent me the bond violation on November 17th.
Right. When we,
and
I think when we got it.
And I believe, I thought it was for a different client and read it for a different client that I have tomorrow. I didn't discuss the bond violation with Mr. Mack. I apologize for that confusion on my part. If we could just address the violation at the next hearing.
I'm not doing that. I mean, because, and I'll be very frank as to why. I mean, first of all, he is here on a drinking and driving case where he was arraigned on October 29th, 2025. So basically the end of October. And then by the 16th, about 2 weeks later, I've got a test of 0.08, almost a 0.9. And then on that test, he failed to retest every 15 minutes as required by the program. And then we also have before that certain periods where he just didn't test. They've also called him on the 17th, realizing this was created on the 17th, so there may be a call, may not be, about his positive test, and have him come report in for an ETG. They left him a voicemail. Looks like they have not, it's not called back. And I did not, Mr. Feltes, I did not do the arraignment. Do you have the BAC for him?
0.177. And I'm reading a report right now, if I may, Your Honor.
Yes.
To the court. This is from the section entitled Traffic Stop from Pittsfield Township Police Report number 231282. Traffic stop, once I activated my emergency lights, the vehicle stopped on Ellsworth with its left turn signal, which appeared to me the vehicle was waiting to pull into the Mount Valley Park. The driver attempted to turn into the park. The driver had driven too far east of the driveway to make a right turn to miss the curb in the snowbank in a U-turn fashion. The driver pulled into the park where it came to stop, and I was able to make contact with the driver. So there was guy driving by the officer as well. I'm double checking out priors right now, but I don't think he has them.
So,
Prior, 2010 prior, do I?
2010.
2010, so it's too old to be a second, but this
got
is
it. So he's got a prior.
Your Honor, respectfully, I do understand my client hasn't followed the bond conditions given to him. The one thing I like to say is alcoholism is a disease. It is a disease, and we place people on bond and conditions upon them. expecting them to be able to cure that disease immediately due to the fact that they caught a case. I do understand that's what's expected. That's what's expected of people, but some people have more difficulty. Some people have more difficulties than others at that. I would ask that you at least allow Mr. Mack one more opportunity to prove to this court that he can take control of that alcoholism and take control of his life.
At the expense of having him drink again and potentially hop into a vehicle and kill somebody?
Well,
I don't think so.
Is there any way possible we could put an alcohol tether on him and a no driving?
I gave him a sober link that he had to blow into. He didn't comply with the testing requirements on that for 2 occasions. And then on the next occasion, on the 17th, he's gone basically about 15, 16 days. And he's got effectively 3 different 4, because he's got 2 periods of missed test where he didn't take his test. He then has the positive test, which will be the 3rd violation. And then his failure to take retest after the positive test is another violation.
Can I just ask my client if he has any explanation to this?
One test that I was doing, I had overslept, missed my time period, but with the retest, I just blow and pay attention to how to do the retest because I just set it down and put it back into the box.
That's fine.
Does he want a hearing on this, or does he want to admit to the violation? He's got his choice.
Do you admit to the violation, or do you want to hear it?
So just
Who wants to admit to the violation?
Yes.
Who wants to take responsibility for actions, Your Honor?
We'll adjourn this matter out to December, the pre-trials in both of these cases to December 3rd, 2025. Anything you want to, and at that time I may sentence him on the violation, but I've got to try to figure out something about this individual because he's not able to make it 14 days before he's drinking, and then he's just not cooperating in the program at all.
Your Honor, respectfully, I would just ask if my client could stay out of jail until that 12/3 court date. He's going to still have to adhere to the same bond conditions. There might be better bond conditions that we could tailor to help Mr. Mack through this situation and help him to get over the problem that he has. Obviously, he does have a problem. Obviously, it's got a grip on him. But as I stated earlier, when people have these type of problems, which I believe is a disease, honestly, when people have these type of problems, they get arrested, they get arraigned, they come to court, they automatically get these bond conditions. They automatically get these bond conditions put on them with the expectation for them to stop. And I understand why the courts had that expectation because we have a responsibility to protect the community. But I do believe there's less restrictive bond conditions that we could tailor to help address the problem with protecting the community and also allowing and helping Mr. Mack to get through this situation, because essentially that's what the court's trying to do is rehabilitate in this matter. So, which I'm not admitted to guilt yet with the case, but I'm just saying, if we could allow him to stay out right now. You are employed, correct?
You want me to let him, after he can't make it 14 days, you want me to let him stay out with the potential of consuming alcohol, getting behind the wheel to go through the weekend where the most alcohol in this country is consumed, that being Thanksgiving weekend. That's what you want me to do?
I would like you to put an alcohol tether on him with a no drive.
And all that's going to do, I get what you're getting at. All that's going to do is tell me he's been drinking. I already know that. So I've adjourned it out to the 3rd at 9. He admits to the violation. I'll deal with how I'm going to sentence him on the violation at the pretrial. But at this time, the defendant's bond's revoked since remanded to the Washington.
Thank you. Yeah.
Thank you.
You and your honorable court have a great day.
You do the same.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Adkins. Mr. Adkins, state your name for the record, please.
Michael Adkins.
Your Honor, regarding the pretrial, I suppose I asked for an adjournment. We're still in negotiations. And then there's a bond issue we should address as well.
Yeah.
So Mr. Adkins had some missed tests and saw a positive test for alcohol. Regarding the missed tests, we have been in touch with the place that he's been testing at in Flint. It seems like there's a little bit of delay in getting those results here. For example, that there was a test on the 31st that when we were here on the 5th was said it was missed. He did test on the 31st. That result is now on that report that was sent by Community Corrections. So we're trying to work out
the alcohol.
Yes. So we're trying to work out the kinks on the delay on getting the test to Community Corrections. So that's the first piece. The second piece is the positive alcohol test. I've had multiple conversations with Mr. Adkins regarding the positive alcohol. I think today he would like to admit to the violation with a bit of an explanation. He is, I think Mr. Adkins' road to sobriety is a pretty long and interesting one. He was addicted to opiates. As of last year, he relapsed, but before that, he was clean for about 3 years. He was completed inpatient treatment. He was working as a counselor at a sober living house here in Ann Arbor. He was a sponsor. He had worked through the steps multiple times. So he's very familiar with substance abuse addiction and the struggles and journey that can take a person on. He obviously admits that they relapsed last year. Again, he struggles with opiates, and he's been clean from opiates now for over a year. Is getting back into that sobriety journey. He is going to AA weekly, and has moved from Ann Arbor, where his primary, problem was, to Flint, so he can. He's living with his brother, who's also 9 or 8 years sober, and re-enter that sober living lifestyle. So Mr. Adkins again admits to the violation. At the last court date, the court ordered him to come here to test in person. He did. The court ordered also for him to come in person today. He explained to me that his mom drove from Saginaw to Flint to pick him up and drop him off here. He's not trying to run from anything. He wants to take accountability for his actions, and I think he's doing that by admitting and trying to work through all of this. So I don't know if you want to say anything in addition to that, Mr. Adkins.
Your Honor, I take full responsibility of the positive alcohol test. I go to NA and AA meetings weekly in Flint. And I just want to not lose my job from incarceration so I can continue to, pay for what I need to pay for and so on and so forth.
He's willing to step up.
But has he taken the test? I mean, I got missed test and unable.
So
I don't have him testing.
There was an unable, I can't remember the dates off the top of my head.
November 12th.
Last week, he said he did go in the 13th and test to make up for that 12th. He did show me a PDF of those results, which were negative. It says on them that the sample was taken the 13th and it was received by the testing facility. The results were received by the testing facility on the 17th. And so he did test on that date. He did test on the 17th.
You're saying he did?
He did. I think here in community, maybe the difference is here, the results are done immediately at community corrections, from my understanding. It seems like at this testing location in Flint, they are sending the tests out. And that's how we get the sample taken on the 13th and the result coming in on the 17th. And that's delaying those results getting to community corrections, which is delaying the results getting to us. So I think that's part of the issue of the delayed or the mistests that are reflected on our reports. But then, like I said, there was one that said he was missed on the 31st, and now we'd have a result for that test. So it shows that he did test, although it is a positive test.
Your Honor, based on the report, I trust defense counsel representations, of course, but based on the report that's before me that I'm looking at, in 1 month, we've had one compliant test, which was November the 7th, which was a test that the defendant had 2 days of notice for. The court recalls on November the 5th when we were here, the court ordered him to test by Friday. So he had 2 days to go to that test. I believe the science and what we're seeing here is a pattern of alcohol use and refusals or missed tests. If the court recalls at the time of arraignment, I let the court know that this was an OWI second offense. The prior is from 2019, which is not that long ago. And the defendant was found passed out behind the wheel of his vehicle, had to have 2 doses of Narcan to even come around at all, and was discovered to have 47 nanograms of cocaine in his blood. I'm extremely concerned for public safety. I think it's great that he's moved in with his brother, but clearly that's not working because he's been residing there since the pendency of this case, if I recall correctly. And we're having these tests that are showing ETG. We had 1 for THC, and we're seeing non-compliance. The concern of the people at this time is public safety. And I'd ask the court at this moment, remand him for the bond violation. If the court is inclined to release them, I would request a scrap tether, as well as the continued intensive supervision for drugs. That's also an issue here.
Anything else?
Anything else from you?
No, ma'am.
So here's part of the problem as I'm seeing it. And yes, I'm concerned about public safety, but I'm also concerned about this defendant. The thing is, you know what it takes to get yourself sober. And I'll just put it in a colloquial sense that what you're doing right now is you're just half-stepping. And you know that. You know that you are not doing what it takes to get yourself there. And that's why things are coming out and working this way for you. You got to make up your mind, young man. If you want to do it, you know how to do it. You've done it. You just have to do it. This half process for you is not going to work. And you got to figure that out. But if you think that what I'm going to do while you're in the process of trying to figure that out is allow you to be out there, be in a position where you decide to get behind the wheel because you're doing whatever and then end up killing somebody, that's not going to happen. So what I'm going to do is I'm going to adjourn this to December 3rd, 2025, 9 a.m. He figure out in that time what he wants to do. But at this time, his bond is revoked, defendant remains.